Good morning, everybody. In what is the second last week of this financial year, thank you very much for everybody joining us today, both in person and online, for the Aitken Partners Business Law Breakfast with today's topic, superannuation and estate planning. Willing it to happen isn't enough. My name is Dylan Birch and I'm Principal at Aitken Partners and I head the family law team here. Today we'll be discussing effective estate planning and superannuation that will help ensure a smooth transition of wealth. We'll be talking about the importance of binding nominations, examine super and estate tax, explore the role of family trusts, and discuss strategic approaches to maximising your estate's value. Now, on any ordinary day, that is a mouthful, let alone at 7:30 in the morning on a Thursday on a bitterly cold Melbourne morning. So, we are blessed today to have three wonderful speakers who will help make sure it's as riveting as possible and that nobody falls asleep in their chair. Firstly, I'd like to introduce one of my business partners, Lizia Lim, who is the principal and head of our Wills and Estates team. Lizia is an accredited specialist in wills and estates and is also recognised by the Doyle's Guide. For people who don't know, the Doyle's Guide is where the preeminent lawyers in their respective fields are recognised in both estate planning and estate litigation. So thank you very much, Lizia, this morning. We also have James Penman on the end. James is a senior associate with our firm within our Wills and Estates team. James has extensive experience assisting clients with all things wills and estates and estate litigation. We're also very pleased to be joined by Bernard McMenamin, who is joining us from Clark & Co, where he's a director and principal. Bernard is a fellow of the Chartered Accountants, a chartered tax advisor, a fellow of the Certified Practicing Accountant, and a trust and estate practitioner. So thank you very much for joining us this morning. The way that this morning's presentation will go, it will be a bit of back and forwards between our various panel members. If anybody has any questions during the presentation, please pop your hand up and ask them as we go along. We want to try and make this as interactive as possible, as well for everybody online as well. If you've got any questions, please type them into the chat facility. They're being monitored live. And of course, if you can't hear any questions or you need to follow something up, please do. And otherwise, Lizia, James and Bernard will be around at the end to answer any questions as well. So thank you very much. So without further ado, I'll start with Lizia. When you look at estate planning, people always think of their wills, testamentary trusts, powers of attorney, but superannuation is something that often gets forgotten about. Why is it important to consider superannuation separately from the rest of your estate planning?
Yeah, thanks Dylan. So superannuation is actually a favourite topic of mine just because it's so curly and trips so many people up. There's not a lot of public knowledge out there about superannuation having a completely different set of rules and legislation to your ordinary assets. So not a lot of people know when I have initial consultations with estate planning clients that super is actually not necessarily covered by your will. So if you go and make a will and think you're all good, that's not necessarily enough. So separate arrangements have to be made for your superannuation. Otherwise, the super might not necessarily go to who you want it to go to. So ordinarily, the separate arrangements would be a binding death benefit nomination in accordance with the rules of your super fund. So if there is no binding nomination, the super fund actually has the discretion to decide how to pay your superannuation, and this may not necessarily be what you would have wanted.
Yeah, so that's obviously a new word that some people may not have heard of before, a binding death benefit nomination, because everybody's heard of a will, everybody's heard of a power of attorney. Well, if you haven't, obviously get in touch with Lizia. But what are the requirements for a valid binding death benefit nomination?
Yeah, so the requirements are all set out in the superannuation legislation, which is important to comply with. And those are that you have to nominate either one of your dependents or your legal personal representative as the beneficiary. So the legal personal representative is the executor or the administrator of your estate. And the portion of the benefit that each person is to receive has to be clearly set out in your nomination. And the formal requirements of the nomination are it has to be in writing, it has to be signed in the presence of two witnesses who both have to be adults and independent of the notice, and there has to be a signed and dated declaration from the witnesses confirming that the members signed in their presence, and the notice must not have expired. So there's a provision in the superannuation legislation which says that ordinarily binding death benefit nominations expire every 3 years. So that's why if anyone has made a binding nomination, often you'll get a reminder from your super fund to renew it every 3 years. If not, then they lapse and are no longer valid. However, the exception to that is that some superannuation trustees do allow for non-lapsing nominations. So that's better if your super fund does provide for that. But if not, it's a bit annoying because you have to renew every 3 years. A lot of people think they have nominated a beneficiary for their super because with the statements, often it has, nominated beneficiary X person. If you haven't actually printed out something in writing and signed it before two witnesses, it's most likely a non-binding nomination that you have, which means that the super fund can take it into account, but is not required to actually follow it. And with a self-managed superannuation fund again, that's different. It has specific rules about what form the binding death benefit nomination has to follow. So it's important if you're making a binding death benefit nomination in a self-managed super fund to have somebody review the trust deed of that fund just to make sure that you are complying with those specific rules.
Now, Lizzie, when somebody does leave superannuation to somebody, is there any rules that govern who it can be left to? Can it be left to your cat, your dog, Auntie Sue? Who can your superannuation actually be left to?
Yeah, so that's a good question. So just, as I've alluded to in the last question, the superannuation can only be paid to a dependent of the member or the member's estate. So no one else is allowed. If you nominate, say, your mum or dad and they're not a dependent of yours, then unfortunately that nomination's invalid and won't be complied with. So in the superannuation rules, there are specific definitions about who can be considered a dependent, and a dependent has to be one of the following: a spouse, which includes a de facto partner, a child, which includes a minor child or an adult child, an interdependent, or a person who is actually financially dependent on the member.
Now, just very quickly, Lizzie, what's an interdependent? Because that seems like a combination of 4 words that doesn't really make any sense in the normal English language.
Well, that's a term that's actually specific to super law. I don't think I've heard of it outside of super law, but an interdependent means that it's a relationship between two people, and all of these elements have to be satisfied, being they have to have a close personal relationship, and they have to live together, and one or each of them provides the other with financial support, and one or each of them provides the other with domestic and personal care. So if all of these elements are satisfied, that could be an interdependent relationship.
Very good. Now, most important... Oh, sorry, yes?
A question there. If the three, with the, many superannuation funds have to be renewed every 3 years. If you've got a nomination and that person becomes incompetent during that 3 years, how do you renew it?
You mean the member who's made the nomination becomes incompetent? Oh, well, that's actually, one of the other questions that Dylan was planning to ask me, but I can answer it now. That is a really good question.
So for people listening online, I think it was the question was surrounding what happens if the member loses capacity during the 3-year period in which they made the nomination before it lapses.
Yeah. So there was not a lot of clarity around this point, but a few years ago there was a Queensland case which suggests that an attorney under an enduring power of attorney for the member can actually make or renew a binding nomination on behalf of that member, even if the member has lost capacity. There's not actually been any Victorian case on that point under the Victorian Powers of Attorney Act. However, if you get your estate planning done by Aitken Partners, to avoid any doubt, we generally include a clause in our powers of attorney which specifically allows the attorney to make or renew a binding nomination on behalf of the member. So we can avoid that problem from arising by specifically empowering the attorney to do that.
Now, I should have mentioned as well before we started, if you do hear some banging or thudding going on upstairs, please don't worry, they're just doing some renovation works up there for new offices that are putting up there. There isn't a horde of elephants stamping around, even though what it sounds like sometimes. So, Lizzie, I'm left money as a binding death benefit, through a binding death benefit nomination. I'm a dependent of that person. What are my tax issues? Are there any? Do I have to pay tax on that money? What happens?
Yeah, so generally, whether you pay tax depends on whether you're a financial dependent upon the member. So with all of those possible dependents that are set out in the superannuation law, not all of them will actually be financial dependents. So one obvious one might be if you're an adult child and you're not living with your parents and no longer dependent upon them, you will be a dependent who is eligible to receive super under superannuation law, but then according to tax law, you still have to, you're not a dependent, so you still have to pay tax on the super. So the Income Tax Assessment Act is again separate from the Super Act and sets out who can receive the superannuation tax-free, and that's generally a spouse or a minor child who's still dependent on the person, a child under 25 who's still studying and still dependent upon the person, or someone who's actually financially dependent upon the person. So if you're an adult child, unfortunately you do have to pay tax on the super. So that's really important for people to consider in their estate planning. Normally it's more tax effective if you're giving your super to a spouse or a minor child rather than to an adult child, and people should take that into account when determining who to leave their super to.
So a lot of
question there. With the superannuation account that's in payout mode, a certain percentage of that is fully tax paid, isn't it? So does the person receiving it, if they're an adult, have to pay tax on the lot, or only on the portion that the tax hasn't been paid?
I believe it's only the portion that tax has been paid. Might be a better question for Bernard, actually.
Yes, well look, when I get to my paper I was going to talk about death tax. And what a death tax is effectively is the tax payable in these circumstances where the payment is not made to a beneficiary. It's tax-free. And perhaps the best way to describe this taxable component is if you've got $1 million in your self-managed super fund and you die and you leave it to a non-dependent, that is an adult child, so it's taxable, of that amount generally I'm finding about a half to 2/3 is taxable, because the taxable component of a fund is basically all tax-deductible contributions you make, all earnings on that fund over the years you've had, say, the self-managed super fund going. The only thing that's exempt is the contributions made where you don't make a tax deduction, which are called non-concessionally tax contributions, which we know as the 300,000 a year, the 100,000, now 330,000 a year, or 110,000 a year. But even the earnings on that is taxable. So if over a period of 20 years I contribute money and I've got this $1 million at the end and I've made a $300,000 contribution, only that 300,000 contribution will be tax-free when the $1 million comes out to the dependent. And the rest will be taxed at 15% if it goes to the estate, or as was said, if it goes direct to an adult child, the tax is 17% because there's Medicare levy there.
Right. Well, does that your focusing there on self-managed super funds,
Yeah.
but if it's in a fund, say like CBUS or one of the others, is the same rules apply?
No idea.
Yeah, it is the same, similar rules.
Similar
Oh,
rules.
similar rules,
In
yeah.
the sense that
But the
the
calculation
taxable and
is-
tax-free
yeah.
component, they do their own tax allocation,
Yeah.
but yeah, if you have a look at your statement, it'll clearly outline what the taxable component, what the tax-free,
Yeah.
so the tax is payable.
And you
the
can
taxable
check that with the
component.
super
You
funds.
can just
Yeah,
have a look at
yeah,
your
yeah,
statement
yeah.
and it will outline in a certain area
Yeah.
unlike components.
Thank you very much.
Yeah.
Yes,
What
sir.
if the fund is on pension phase, over pension amount?
Yeah. So the question was, what happens if your fund is in pension phase? What are the tax implications there?
The only implication is the cap of 1.9 million. If I've got 3 million in my self-managed super fund and I start a pension for 1.9, an actuary has to calculate the 11/30th, if you like, in that example, that's taxable of the fund. It's that, and that's tax paid on it. And I'll talk to how we plan that when I get to my paper, my bit of the paper later, that it's a matter of trying to maximise if you've got mum and dad or two people in the same fund who are spouses, whatever. The idea is to ensure that they both have at least the 1.9 million each, and in the excess, and I'll talk about that perhaps when the time comes, but the excess is taxable when the fund's in. So we have a number of pension funds that are in pension mode, and some, the members got 3 million in the fund, 1.9 million the earnings on that is tax-free, and the only 1.1 million it's taxable at 15%.
So whilst we're talking about self-managed super funds, Lizzie, what happens if there isn't a binding death benefit nomination through your self-managed super fund when you do
Yeah.
pass away?
Yep. So as I sort of briefly mentioned before, if you don't have a binding death benefit nomination, then basically the super fund trustee will get to decide who gets your super. So that's the case if it's a self-managed super fund or not. It's just that in a self-managed super fund, the trustee of the super fund is usually one of your family members or your spouse generally. The trustee of each self-managed super fund will set out the process for what happens to the benefit if the person doesn't have a nomination, and usually the trustee says that the super can be paid to any one or more of the deceased dependents or the deceased estate, and that's at the trustee's discretion. And so this is where it becomes really important in your planning to look at who will assume control of the self-managed super fund or become the trustee after you pass away, because they will generally have almost absolute power to decide who to pay the benefit to, and they might be able to get away with even paying the benefit all to themselves, even if that's not what you actually want. So there have been some cases where there was a pretty well-known case of Katz and Grossman where the deceased was a member of the self-managed super fund with his wife, and he and his wife were the co-trustees, but when the wife died, so they both had a son and a daughter. When the wife died, the deceased appointed his daughter to become the co-trustee with him. So when the deceased passed away, the daughter had sole control of the self-managed super fund. The father had made a non-binding death benefit nomination, and his wishes were clearly that his super should be paid equally between his two children. However, the daughter assumed control of the fund, ignored this, and just paid the benefit to herself solely. The son did challenge this, but he was ultimately unsuccessful just because of the wide discretion that the trustee afforded the trustee to pay the benefit. And there was also another case where the deceased member was in a self-managed super fund with her husband, and they were both members and trustees of the fund. She put in her will that she wanted the super to be paid equally between her two children, and under no circumstances was her husband to receive her super. However, unfortunately, she didn't make a binding death benefit nomination. And once she passed away, what happened was the husband assumed control of the super fund and just paid it all to himself again. The children were also challenged that, but were unsuccessful. Therefore, these cases highlight how important it is to actually look at who will become the trustee of your self-managed super fund after you pass away. And if there's a corporate trustee, you need to look at how control of that corporate entity will pass upon your death and get specialist estate planning advice on your structure and the succession planning that might need to be put in place for the company and the super fund. It's really important not to skimp and skip this step, as it might result in your wishes not being fulfilled by whoever takes over.
Could similar situations arise by a power of attorney in a fund like CBUS?
Well, generally, a similar situation could arise if a power of attorney has a duty to administer the person's funds in accordance with their best interests. So a power of attorney would be in breach if they were to withdraw all the money from the super and pay it to themselves, for example. So if the person was still alive, so that would be something that could be pursued through the perhaps the compensation provisions of the power of attorney legislation.
All right, well, we might just quickly turn now to what happens when things go wrong, which inevitably seems to be a bit of the time in estate planning and superannuation matters. So, James, in a self-managed super fund, can a trustee's decision on how to pay the super be challenged?
So short answer, yes. As Lizzie mentioned, trustees have like a very broad discretion, which accountants and financial advisors like. Gives a lot of flexibility with the estate planning, but they're still confined by the trustee, and they still need to consider all the beneficiaries. They need to act reasonably. They can't act where there's a conflict unless the trustee provides. And there's a big case sort of a few years ago where someone had essentially paid a distribution to themselves, which they could do under the trust deed, but the court said, sure, but that was so grotesquely unreasonable, I think the word was, so grotesque what you've done, I'm going to remove you and set that decision aside. So yes, very broad discretion, but the court can still step in and cause trouble if you're not acting in good faith.
Yeah, okay. And does that go for binding death benefit nominations as well? We sort of heard Lizzie talk about that a little bit, but can they be challenged, or are they just entirely binding?
If they're valid, great, but you can have technical issues with it if you put the wrong people, if they're not eligible to be, a death benefit nominee, beneficiary. There's also issues. I had one of my first cases, a lawyer actually with an estate where someone knew they were going to pass away. They had terminal cancer. They had got everything in order, or they thought they had, and they had done their superannuation death benefit nomination, but it was emailed, but I think to the wrong email address for the something ridiculous. And so we were able to find the email, but the trust fund just said, no, it wasn't received. We're not going to abide by it. And, you could probably contest that decision and all that. We didn't have to in the end, but yeah, you can contest it on technical grounds, if it's got the wrong name there, for example, or also on delivery where the trustee says, well, I never actually got it, therefore I'm not going to be bound by it.
Yeah, okay. Well, and the next thing sort of that I was thinking about as well is if you're named an executor or you're an administrator under a will, can you claim a superannuation benefit personally?
You can lodge the form, but you can be in trouble. Again, there's another case a few years ago where someone was the administrator of an estate and they had claimed superannuation in their personal capacity, which a lot of people think that's fair enough. Maybe I'm the partner or I'm a dependent, I'm going to claim the super. But if you're an executor or administrator, you've got an obligation to pursue that for the estate, unless the will has a clause that says, I'm going to allow that to happen, which we generally have in our wills here at Aiken. But you can be in trouble, so yeah, just be careful with that. Speak to a lawyer about if you're an executor and a beneficiary, perhaps of a superannuation fund. just make sure you're not going to be sued by the beneficiaries later who say, well, you've claimed it, you should have got it for us for the estate. So, yeah.
Yeah, okay. And so what are some of the other common disputes that arise in relation to superannuation?
I suppose most common is where the trustee will distribute funds, but they'll do it in a percentage that people aren't happy with. So if you've got, I think the most common scenario I see is you've got the new partner, and then you've got the kid from the previous relationship, so the stepchildren, and they're going, well, who's it going to go to? Is it going to the children or is it going to the new partner? Which I think, they can have valid arguments for both. And the trustee might say 50-50, and they say it's unfair, so we want to change the percentage around. That can happen a fair bit. Sometimes the trustee will say, I'll pay 100% to the children and leave the partner out, and they'll contest that. And then another one, and it's a matter I'm dealing with at the moment, where you might have someone who says, well, I'm the partner. I live with them, we shared bills. And the children say, well, no, you weren't actually the partner. You're not married. You're not in a registered relationship. You were not a de facto partner. And so you're going to have a fight about, is that person actually the de facto partner who can claim the super?
Something I know all too well about in family law
Yeah.
is de facto partners and what it actually takes into account, and it's never straightforward.
And the rules about relationships are different in estates in Victoria, in superannuation, and I presume in family law as well.
Yeah, they are. Are there any other examples?
So those are kind of big, public superannuation funds like Australian Super or CBUS. If you've got like a private fund, like a self-managed superannuation fund, you can go to court. Courts have this sort of overarching power and oversight role for all trusts in Victoria. So deceased estates, trusts, those self-managed funds, they can step in and they can say, well, that's unreasonable, that you shouldn't have done that, that's a breach of your fiduciary obligations. So, yeah.
Yeah, so speaking of court, what is the process for a superannuation dispute?
So,
what do you need to do?
So you can go to court. It depends on the nature of the fund, the nature of the dispute. So you can go to the Supreme Court, or typically you'd go to AFCA, which is the Financial Complaint Authority.
Sorry, what's AFCA? Just the actual AF. What is it? What is it?
Australian Financial Complaint Authority, I believe.
Very good.
Too early for that.
For all those playing at home.
And they're essentially, if you've got an issue, you can make an online complaint these days. It's not an objection or application, it's a complaint. And wow, they didn't like that.
yeah. I don't want to go to AFCA either.
Oh, AFCA. They heard me talking smack. Yeah. So you can apply. You can apply an objection to AFCA. And I've just done one of those this week. And the first thing that AFCA will do, they won't even look at the matter. They'll simply get all the parties on a phone call and say, can we hash this out? Can we resolve it? And when I looked at their stats recently, I think about 40% of all matters will resolve at that stage, which is good.
Yeah, wow.
If you don't come to an agreement, then it will go to the next stage where they'll review it. So AFCA will review the trustee's decision and they'll give a preliminary review. They'll say, based on the evidence and the law, we think this is the answer. And the parties can agree or disagree. If they don't agree, it goes to the Ombudsman for a final determination. And the only way to appeal that is to go to the Federal Court of Australia. So there's a few steps there, but AFCA is the first protocol.
All right, and apart from seeing our magnificent estate planning team at Aitken Partners, how can you avoid a superannuation dispute?
Well, you said besides seeing us, well, first of all, see a lawyer, just to double check. But aside from that, I think the best thing you can do, and I know it's a bit kind of tedious and boring, but just put in your calendar. Once a year, once every 2 years, once every 3 years, just check your will, check your superannuation. I speak to so many clients, they have no idea about superannuation, needing a death benefit nomination. And they might have most of their wealth in superannuation, might be half their estate, together with their property and the super from their job that they've built up, and then they haven't even done a death benefit nomination or a binding one. So just review it, chuck it in your calendar, make sure the will's up to date. You might have children who have grown up, you might have nephews and nieces you want to include, you might want to pay your super to your estate, or just diarise, check it every now and then. Yeah.
Very good. And so now, Bernard, I'll turn to you just quickly, or not quickly, sorry, but just to have a discussion about some more of the tax side of things with respect to superannuation as well. So when people are monitoring their superannuation, what should they be looking at to make sure things are as tax effective as possible?
If I could sort of put it into zones and say if you're 40 or 50 and you're building up your super to retiring at 65, I think really you've got to obviously maximise your contributions, put in some after-tax savings if you can. But the one that's often overlooked is equalising between the two partners, if it's mum and dad, husband and wife, partners, whatever. There's no point getting to 65 and finding dad's got 2 million and mum's got 500,000. There are ways to fix that later, but if you can do things like, you know, you can elect to transfer your contributions that you've made in FY22 to your spouse in FY23 by a transfer. If there's some spare funds, you can put some contributions in on behalf of your spouse. But in all that, you've also got to monitor the death tax. So in my silly example earlier of one of the partners having 2 million and the other one having 500,000, if when that 2 million person gets to 65 or retires, they can pull 300,000 out, give it to their spouse who puts it back in. So 2 million becomes 1.7 and the 500 becomes 800,000. You do that every 3 years till they're 74, you've probably equalised it. But you've also got another minor benefit or a significant benefit that you don't see. And that is when the second spouse puts that 300,000 back in, that's not taxable on her or his death. And you've reduced the death tax of the other spouse who's pulled the money out. So there's a bit of throw up a red ball and down comes a black one, but they're planning things that are often overlooked by, I dare I say, accountants, in that to equalise is very important, and then going on from that is that death tax situation, which will probably be part of my next question.
A bit of Nostradamus, because it might be. Because when people do retire, what are some things people should think should they be doing with their super?
Well, I've sort of talked about one already. There's obviously commence a pension.
Yep.
Grab the 1.9, but unfortunately, if one's got $1 million and not 1.9, you probably do that recontribution strategy first. But also, of course, what we like to see in place is that what's called a reversionary pension election, death benefit nomination. So automatically on death of the first spouse, there's a reversionary pension, and you then have a tax benefit for 12 months of the two pensions, including the deceased, being tax-free. So to make it very easy, Dad's got a 1.9 million in super, in pension, and so has Mum. Dad dies. That 1.9 of Dad's, if it's part of a reversionary pension to his wife, which is a binding death benefit agreement in the deed, which can't be overturned, then that 3.8 million, the 1.9 by 2, is tax-free for a year. Then, in a year's time, in my example of Dad dying, Mum takes Dad's pension, and that becomes her pension, and her pension goes into accumulation. So we haven't gone from losing any money because one of them died. The 3.8 million is still in super. Admittedly, Mum's 1.9 is taxable, but you know, it's a pretty good win-win. And then, of course, on Dad's death, you've got a lot of considerations to make, because obviously you've then got a sole beneficiary or a sole member, and what does he or she do with all that money, which I guess is the next question.
Yeah, so what does happen when there is only one member left in a fund, Bernard, say for an SMSF or something like that?
Well, we're finding, having a lot of older clients, that obviously if in my example of Dad's died, as Mum ages, we need to look at avoiding this death tax. I've just had one recently where the fund had 20 million in it and 10 million was taxable. And by getting it all out the day before he died, or a week before he died, we saved 1.5 million in death tax. And I know that's only one example. I've only ever had that experience once of that size of money, but it just shows you the sort of issues that can be there. And this is where I think, and I'll turn this back to the lawyers, particularly I guess to Liz here, is that we really need that financial power of attorney for the son or daughter to say, Mum's dying, let's wind up the super fund. If he or she's got capacity, then that's okay, but if they've probably not got capacity, if they're 94 years of age and on their deathbed, and this is what happened with this particular case. The person was 90 and they didn't have the capacity, so the children got together as the financial powers of attorney and did it. But that can have its abuses, and I won't go into that because that's more of a legal question, but we like to get the money out. In this case of the 20 million, we had 10,000 left in the fund, big deal, we paid $1,500 tax. So that's pretty important, I think.
Yeah, absolutely it is. And so you're talking about health starting to deteriorate. With respect to, like, we look at Alzheimer's or dementia or things like that. When funds are sort of, as you're saying, a power of attorney is so important because it sort of safeguards those sort of things. Is that against things like Alzheimer, dementia, those sort of health deteriorations, or is it more broad than that, which can just be cancer, old age, all of those sort of things?
I'm not sure to answer it, I guess, but depending on how you draw that. I would have seen a financial power of attorney, and lawyers would perhaps know better than me, is that they can do anything on behalf of the person even if they're not sick. You know, as long as, and I think there's conflicts in there, of course. If you've got 3 children, you make one a financial power of attorney, that the abuse and all the case law that the lawyers in the room would know. But someone's got to have that power to say, you know, Dad's dying, Mum's dying. But one interesting thing is that a medical practitioner told me that there's very few cases where, and often a client will say to me, what if I drop dead today? It's something like 1 in 1,000, 1.1% chance that someone will die suddenly. A leading doctor who's a client told me, he said, Bernard, he said, unless it's a car accident or somebody shoots you, you're not going to die just like that. The odd person will drop dead of a heart attack, of course, or walk under a tram, as I say, but it's very, very rare. So if you've got 100 clients in self-managed super fund and they're all elderly, it's very rare that one's going to die unexpectedly, and you normally have some time to have the financial power of attorney get that money out of the super fund and into the estate, or into their own name and then eventually to the estate.
So we've been sort of talking about, sorry, yes sir.
Just a quick question. If you've lost confidence in the financial capacity of your powers of attorney appointees, and including financial capacity, you've lost confidence in their ability to manage money. Can you have professional people appointed instead?
So I think I might just repeat the question for everybody online. The question was, if you've lost confidence in who you've appointed as your as your power of attorney, as your attorney, can you have a professional organisation step in to assist with the administrative side of things? Lizzie?
Yeah, well, in short, yes, if you still have capacity and you can make another power of attorney, then you should make another power of attorney which revokes the old one. And in your new power of attorney, you can appoint a professional person or a trustee company to administer your affairs if you don't have confidence in any of your family members.
I think that's an important point as well, Lizzie. It is all these documents that we've talked about: wills, powers of attorney, binding death benefit nominations, super SMSF trust deeds. They can all be continuously updated and changed as times arise, can't they?
Yeah, definitely. Yeah, they're not static in time. You can always change it based on your circumstances, and we always recommend that you should review your circumstances every few years. And if you don't like something in your existing documents, just go into your lawyer and change it.
Exactly right. Now, Bernard, we've talked about elderly people or people in later stages of life passing away. What should people do in the horrible situation when someone young is unwell and is looking to access their superannuation?
Well, fortunately, I've never had this situation for a client, but if a younger member is seriously ill, the tax office requires that to pay out superannuation to them, you need 2 doctors' medical certificates saying they have less than 12 months to live. It's that simple. And if you can't get that, you can't access the money.
Well, that's a really
As I understand it.
a very horrible situation, but it's good to know that there are options available to people.
Yeah.
One thing, Lizzie, I think would be really helpful for people is just to talk through quickly what practically they should be taking into account when they're coming in to see a lawyer to discuss their superannuation issues. What should they have thought about? What should they have? What should they bring to that first initial consultation? Just so people are aware of what to start thinking about now.
If there's a self-managed super fund, you should always provide your lawyer with copies of the super fund trust deeds and any amending deeds, because every super fund's different. There's different deeds that you can use, so we don't know what arrangements to put in place for the self-managed super fund unless we have all access to all documents. If the deeds have been amended since then, we need all the amending deeds as well. For example, if If the trustees have changed, need to see the deed appointing the new trustee. If there's a corporate trustee for your self-managed super fund, we need to see like the ASIC details showing like who the directors are, who the shareholders are of the trustee company, so that we can, and ideally the company constitution, so that we can see what arrangements there are in place in respect of that company. I guess just, you know, they should also sort of think about, you know, who they would like to receive their super, who their family members are, who's dependent on them, and you know, what the most tax effective way, which is what we can advise them in conjunction with their accountant as well.
Excellent. Very good. Sorry, Bernard.
It's fine.
No fun. No, so it's a good opportunity now. If anybody's got any questions, both online and in the room, as to anything to do with estate planning or the superannuation side. Yes, sir.
It might be a silly question, but when should you consider to have a will, basically? Because as a young person, I would, haven't even thought of it, you know, to have a will in place. So when will be a good time to have it?
I'll just repeat the question for everybody online. The question was surrounding when should somebody look at getting a will, especially for a younger person. When's a good time to think about getting a will?
So I do estate planning, but I also do a lot of estate litigation. So I see when it goes wrong, and when it goes wrong and people don't have a will or they haven't updated it and they think they don't need one for whatever reason, it can be very expensive and very ugly. And I would say the cost of doing a will, even when you're young, and you know, I've done a will for a client just yesterday and I've set it up, they don't really need to amend it in the future. If they have more kids, grandkids, it's all there. They can update it if they want to, but they can just set and forget it. And that small cost now, you know, if you go to court over an estate dispute, you know, if you go all the way to Supreme Court, it's tens of thousands of dollars for each party. So spending a few hundred or a couple thousand now to speak to an accountant, financial advisor, get your wills and powers of attorney, and hope you don't need them. You know, a power of attorney, you hope you don't have to rely upon it, but just having it there can save so much heartbreak for family and costs and delays, and doing it now will avoid, you know, your family, your beneficiaries 10, 20 years from now having to go to court, having to go to VCAT, things like that. So I say it's a great investment to do now. Even if you don't have assets now, you might have assets in the future, and that will still be valid. So.
Rick?
No, that's what I was just going to add to that. It's as soon as you've got an asset of value, or look like you'll have an asset of value, or if you've got somebody, a relationship, not necessarily a romantic relationship, but somebody who you expect will receive it. Because if you don't have a will, a piece of legislation will determine who gets what.
Well, I think that's a really good.
Well, I mean, subject to fights.
So I think that just very, very quickly, Rick, I think that's an important point. What happens if you don't have a will, Lizzie? Because a lot of people just assume it all just goes to my husband and wife, it all just goes to my kids. That's not exactly the case, is it?
Yeah, well, there is legislation that sets out who gets your assets if you don't have a will. That's the intestacy laws. So generally it does provide for a portion to go to your spouse or de facto partner. And if where it gets tricky is if you happen to have a spouse but children who are children of a previous relationship, not of that spouse, there's a distribution that's set out which might not be in accordance with your wishes. And another important thing about that is you might think, look, I'm right with the intestacy legislation, it'll all go to my spouse, and that's okay, but it's the important thing is also when you make a will, you get to choose who your executor is and who gets to administer your estate. And with the intestacy legislation, you don't get to choose. It's generally the person who's entitled to your estate or the people who are entitled to your estate. So if you have multiple children, for example, you don't get to choose which one of those children administers your estate, and there could be fights about that.
Good. Sorry, there was a question online.
I've got two questions. One, would you recommend taking out life insurance with your self-managed super fund? And what are any issues or risks that would be associated?
Not a registered investment advisor, but obviously from a life insurance protection point of view, it would be fine. The premium would be tax deductible in the fund, but when it comes out of the fund, if you die, it's taxable as high as 32%, depending on who receives the proceeds. So it's not something that we can't discourage, but we don't encourage it either. It's just a bit messy. It's best to just have it out in your own name or with a spouse as the beneficiary.
And sorry, one more. Yeah.
One more from online that was submitted is just asking some questions about the jurisdiction when you've got crossover with super power of attorney. Does it matter with different states?
It's a good question. Lizzie?
Well, so there are different laws in each state as to powers of attorney and succession. It does get very complicated, but with powers of attorney, generally there are provisions in each state's Power of Attorney Act which says the powers of attorney made in another state are recognised over there. So if someone makes a power of attorney in Victoria, it can still be recognised in every other state of Australia.
Good. Yes, sir.
Just one quick question. If you've been obliged to move money out of your sewer account back into an accumulation account to meet the limit requirements, can you move it back the other way?
Not to set it, no. You have to eventually
None of
pay
it.
that.
You can't.
No, once you
bring
hit
it
the cap, once you hit the cap of 1619, whatever it happens to be, soon it'd be 2 million apparently, and you, in my example, you inherit that from your spouse, or you've got it, that's it. The other stays in accumulation. You can't do anything else. You can pull it out of the account and spend it when you're 65.
There'd be tax consequences with that then.
No, not tax.
Well, the
consequences.
accumulation fund's taxed at 15%.
In the fund, but once you pull it out, it's yours. But of course, in your own hands, you might invest it and pay 47% tax if you've got high income. So you'd leave it in the fund, wouldn't you?
Yes.
Yeah.
And sorry, there's a question down the back. Yes, sir.
Kind of two parts, one question if I can. One, can you explain the difference in outcomes in the deceased estate between joint tenants and tenants in common? Okay, and also, so obviously super's national law, but the state laws, state law is estate-based laws and family law interaction. For example, I understand in New South Wales, I think an estranged spouse has 12 months in which they can bring family law proceedings against a deceased, so they can kind of get to see the will if they don't like it, commence family law proceedings against the estate.
Well, I'll answer the family law question. So the family law question.
Some of it,
Yeah, sorry. So the first the family law bit was with respect to in New South Wales, the spouse has 12 months to make a claim. Under the Family Law Act, you can't make a claim on somebody who's passed away. So as soon as somebody dies, any option under the Family Law Act is extinguished. So then obviously you've got your rights under the respective states.
Are you referring to challenging a will after the person died?
I'm not a lawyer, so I don't know.
Yeah,
Obviously,
so
there's different laws in different states.
I
Yeah.
know in New South Wales you do have 12 months from the person's death to contest their will, essentially, if you don't like it.
Family law is Commonwealth legislation, so that's unified obviously everywhere except for Western Australia, which has essentially mirroring laws that are different. So family law is, obviously once somebody passes away, you don't have a claim under the Family Law Act, but obviously then each state has a different claim with respect to we call them Part 4 claims in Victoria. It's Part 4 of the Wills and Discrimination.
Part 4 of the Administration and Probate Act in
Yep.
Victoria, but it's the Succession Act in New South Wales, and that provides 12 months, but in Victoria we've got 6 months from the grant of probate.
And just in the property question, so tenants in common and joint tenants, that's a really common thing that comes up in estate planning, because I'll speak to a client and I'll say, who owns the property? And they'll say it's in both our names. And I'll say, is it joint tenants or is it tenants in common? And they'll say, what's the difference? So joint tenants means that when someone passes away, the survivor gets it automatically upon death. And all you need is the death certificate. If it's tenants in common, it doesn't automatically go to the survivor, it goes to their estate. So you need to get the death certificate and the grant of probate, and then you can transfer that share. So it's really important to know joint assets won't form part of the estate. Joint bank accounts, joint properties, things like that.
James, just very quickly, you mentioned a new word there, grant of, or 3 words, grant of probate. Just very quickly, what is a grant of probate?
So when someone passes away, you've got a will. The will appoints your executor. They're the person who stands in your shoes when you pass away, and they'll administer your estates. But anyone can have a document and say, I'm the executor. You actually need to go to court and prove that is the last will of the deceased. And that process is called applying for a grant of probate. So if you're trying to transfer property and you say, I've got the death certificate and I've got the will, the Land Titles Office will say, well, great, this is just a piece of paper. Who are you? I don't know anything about this. If you've got a grant of probate, that's a document that lets you go around in Victoria saying, I have authority to deal with these assets. So I always say the two key documents is getting the death certificate first and then applying for the grant of probate. And with that, you can just administer an estate.
Perfect. Very good.
So when you say property, you're talking about real property?
Real property.
So houses, for example, with joint tenancy and joint, tenancy common and joint property. Yes. Yes.
Could I just make two comments? I neglected to mention earlier that one of the major tax planning options for older people in their self-managed super fund is downsizer contributions. You sell your home, you've had it for 10 years, you've lived in it for some of that 10 years, you get $300,000 each, can go into super tax-free if you do it within 90 days of settling the property. And a lot of people overlook that. We actually monitor our clients now through our ASIC reports and say, oh, he's moved, we better tell them about the downsizer contributions. That's something that not a lot of people know about. That's $600,000 between a couple, and not only that, if only one of the couple own the house, you can put $300,000 into each. It's quite a generous situation. And finally, not for today, but the other big contribution to super is a small business concession when you sell your business. You can roll millions into your super fund, literally millions, tax-free. Not to be talked about today. And finally, if I go back to the question of the young man there talking about someone dying young, what happens, now if I could ask the questioning that I'm up here,
Of course you can, Bert.
what happens when a 22-year-old dies without a will, but he's got a $2 million house that Grandma gave him? What's the rules where he doesn't have any children, doesn't have any brothers and sisters? Where does it go? What's the intestacy rules there? Isn't there some rule that you can't leave it back up, it can't go back up the line or something?
Lizzie?
So yeah, the intestacy law says first it goes to your spouse and or children, and if there's none of that, then grandchildren, and then next in line's parents. So
it does
people
a bit,
who
yeah.
are young generally still have
Yeah.
parents, so it goes back to
yes,
your parents
I see.
equally.
Yeah, just some concern.
The doyen of wills and estates in Melbourne, Mr. Rob Davey.
Bernard, the downsizing contribution,
Yes.
if you are both over 75,
Mm.
when you downsize, can you still make that contribution?
Yes, you can. Yes, you can, yes.
So is there an age limit?
No. Well, probably 100. You'd be dead by then.
Very good. Any part? Yes, sir.
So how CGT applies to this person to transfer their main house to different beneficiary, like their spouse or their parents?
So the question, just so I get it right, the question was what CGT, capital gains tax implications, are there from somebody willing, so somebody dies, then they want to transfer their property to either their spouse, children or something like that. My understanding is there is none, because it's passed through under a will, but I will obviously defer to greatness over here.
Is that me?
Yeah, that's you, mate.
Yes, that's correct. There's one great thing about our laws. Whilst we pay too much tax and we have all these funny indirect taxes, we don't have inheritance tax like the UK, for example. There's one great thing: assets passing to a beneficiary, there's no CGT, there's no capital gains tax at all. Obviously, the principal residence is exempt anyway, but if you had other assets, not a problem. The real problem that we're finding coming along is, perhaps our practice being an old practice, founded in 1925, is we've got trust deeds that are now 70 years old, and they're going to vest when they're 80 years old. We mustn't forget that vesting of trust could cause a CGT event, and that's quite a critical issue. Although I see a prominent barrister who I won't mention names, who we all know here, recently won a case in extending a vesting date, but that's going to be a future estate planning issue, I believe.
Mr. Mikazak, yes.
Just to add to Bernard's question, the other real practical issue is, yes, we can roll them over and we don't pay tax, that's fine. But the real issue is record keeping. Who bought it, when did they buy it, how much is it, what's the cost base? Because the person who takes it over takes it on their cost base.
Well, well, there is only two issues. One's a
Sorry,
pre or...
we just repeat that for
I'm
online.
sorry.
Yeah. So obviously the comment from the back of the room was surrounding obviously keeping accurate records of when people bought properties, when people bought shares, when people bought different bits and pieces to make sure there's an accurate cost base. Now, Bernard, just very quickly, what's a cost base?
Well, the cost base is what it cost you plus any holding costs, for example. There's only two issues. Was it pre or post 1985 when the Capital Gains Tax Act came in? If it's pre, you get a valuation of date of death. So if I die today, it's the valuation of my property today. If I bought it before capital gains tax, if I bought it post capital gains tax, it's my cost base, which, as the gentleman at the back said, that can be an issue because did I keep records of my 1990 property that I bought 24 years ago? Or whatever it was, 34 years ago.
Yeah.
34 years ago.
Time flies in the accounting world.
It does. What are the records? That I agree. That could be an issue. That's why we do encourage our clients when they leave assets to their children to leave it into trusts, not in their own name, because then trusts don't die, except every 80 years. But yes, it is an issue. I agree.
Yes, sir.
Yeah, if you've got a spouse in a nursing home, and normally you have to raid the super fund to pay the refundable accommodation deposit.
Yes.
If that person dies before you, my understanding is you can't put that money back in the super again. Is that right?
Correct. Once you pulled it out, yeah.
Sorry, just for people online, the question was, if you have a spouse who is in aged care and you have to raid the super fund to get the money out to pay for the accommodation bond, and then that person passes away, you can't then put that money back into superannuation.
No, I believe that bond would go into their estate, and if the husband in this example got the money, that could be another dispute. The kids could say it's mine.
Very good. So I think we'll leave it there for today, guys. Thank you so much for everybody who's attended, both in person and online. Thank you for your engagement. Thank you very much to Lizzie, Bernard and James this morning for their presentation. If you'd like to stay around, there's food and tea and coffee left there. Please help yourselves. And otherwise, wish you all a wonderful Thursday and stay warm. Very good. Thank you.
Thank you.